My name is Esther Fifelsky, and I'm with the City of Holland. And I twice a year will do a tenant landlord training on any particular topic related to this area. Today, I am really honored to have Judge Bradley Knoll from 58th District Court, who will be opening the session. We also work very closely, as you can imagine, when we do this type of work, we work very closely with community partners. I work very closely with the Good Samaritan Ministries here in the City of Holland, and Jessi Christensen will also be speaking. We also work with the Legal Aid of Western Michigan, and Dolores Trese will also be presenting today. So I think what we'll do is we'll go ahead and get started. Judge Knoll has been with the Ottawa County 58th District Court for 20 years, and it's my pleasure to invite Judge Knoll to speak about the state of evictions in the City of Holland.
All right, thank you. Thank you for inviting me. Thank you for doing all the organizational details, Esther, that were necessary to put this on. I have to chuckle a little bit. I'm also making a presentation next month at the Michigan Supreme Court's Judicial Conference on an update in landlord-tenant proceedings, and we have much the same general topic here today, and there's really not much to say when we're talking about updates. I feel like the guy at the geologist convention who's asked to give an update on erosion. I mean, it's out there, but it's happening all very slowly. And when I think about, I sort of think about landlord-tenant proceedings in the historical context of before COVID, during COVID, and after COVID, and what changes were made during that period of time. And the same three issues were present before, during, and after, though the approaches were somewhat different. So any tenant that comes in to see me today, or had come in to see me 3 or 4 years ago, time in between, there was three things I wanted to make sure they understood. Number one, that they have the right to contest the proceedings. They have the right to a trial or some sort of evidentiary hearing to determine whether the allegations of the landlord are true, whether the amount that they claim is past due for rent is actually past due, whether the landlord has complied with the requirements of the lease to keep the property in reasonable repair. If there's any claims along that line, that they have the right to a trial to contest those proceedings. And they have the right to be represented by an attorney at these proceedings, that they may qualify for representation through the legal aid office, that they should call the legal aid office if they have any questions, or that they're free to hire an attorney of their own. And that's the dilemma of landlord-tenant proceedings, where you have about 95% of the landlords represented by an attorney, and about 99% of the tenants are unrepresented. That by that very fact, there's the scale tips toward the landlord at the beginning of the proceedings, just because they've got the lawyer and the defendant doesn't. And I'm not allowed to put my thumb on that scale, but I at least try to make sure that the pleadings can be developed, because the tenant typically can tell me what the problem is, but can't phrase it in terms of this is a legal defense because they violated the statutory covenant to keep the property in reasonable repair. So it sort of requires some work from the judge. And then the third thing that I've always advised tenants of, continue to advise tenants of, is that I will give them time to seek rental assistance that might be available to them. And obviously, the availability of rental assistance has varied. We've always had Michigan Department of Health and Human Services, the State Emergency Relief Program, available for some qualifying tenants. And obviously during COVID, we started with the eviction diversion program and then moved on to the SARA program, and the court operations changed dramatically then. I was no longer trying cases. I was just sort of directing people back and forth to places where they could get help and assistance, and we could get our orders entered for conditional dismissal. And that's still the case today, except we don't have the SARA program, or we don't have the eviction diversion program. We have the Ottawa County program that was recently implemented, and Ms. Christensen will be talking to us about that. But as far as how the court operates, we're still operating under an administrative order from 2017 that all of us judges had expected to be replaced by a modified court rule at late in 2022. It still hasn't happened yet. It's complicated in terms of when the court can enter a default, when the court can enter a default judgment. But as far as, you know, how I operate, and I think the other judges in Ottawa County do very much the same thing, is number one, we want to make sure that before we're issuing any orders or judgments of possession or orders of eviction, we want to make sure that the tenant has exhausted all of their possible remedies for getting rental assistance, either from private agencies or from the government. And just making sure that time has been allotted to them to do that, encourage that the landlords and the tenants, because frequently, even if there is rental assistance, it won't cover all of it. The tenant may or may not be in a position to pay the full balance that they owe, trying to encourage some sort of installment provision, but we're not in a position to impose that on the landlords. I've been pretty happy with what the landlord's willingness to engage in these negotiations and allow for extensions of time in appropriate cases. Obviously, some of them are less willing than others, but really things are remaining the same. I could go into the details of the administrative order that we're operating under, but it's complicated, and I think every judge interprets it in a different way. The important thing is that at the first appearance, there's not going to be any orders or judgments entered, that we make remote appearances available for the tenants or the landlords. The landlords take much more advantage of Zoom technology than the tenants do. I think perhaps justifiably, the tenants trust their automobiles more than they trust their devices or their apps, but which is problematic, because whereas you've got somebody appearing by Zoom and you've got somebody in person, getting them together to discuss things is a problem. But that's just an overview of where things are now. I guess you can say we're back to normal, but it's a new normal. And we learn every day better ways to do things. And but first and foremost, we remember that every tenant has a due process right regarding requests to dispossess some of their property. Due process is defined as notice, specific notice of what the request, what's being sought, and an opportunity to be heard. And it's my job to make sure that they are fairly heard in these matters, as we rarely have jury trials, though they do have the right to a jury trial. So unless there's questions that come up during or later, and I'll stay online, that's my presentation.
Thank you, Judge Knoll, for that. Appreciate all the work that you do at 58th District Court, and recognize that it's a big job for a community that has a lot of rentals, rental units. The next individual who will be speaking is Jessi Christensen from Good Samaritan Ministries, who handles the eviction prevention program. And Jessi, I am going to make you host here.
Okay. Esther, is there a way that well, it might not matter because Jessi will be using a PowerPoint, I believe, but or sharing her screen. but when we speak that we take up more of the screen than just the little box that we're in.
Yes, I have you on full screen on my screen, but I believe that you need to control, like, if you want to see
Gotcha.
Jessi as full screen, then you need to go in and make the speaker view. And Jessi,
thank
I
you.
am making you the host.
Okay.
Thank you for your patience, everyone. Okay, Jessi, you're on.
All right. Can everyone see that? Let's try this once more. All right.
Yep, that works.
That
Okay.
works.
All right, great. I can see some faces as well. I just need to move there. There we go. Hi, I'm so grateful to be here today. Thank you, Esther, for coordinating. It's a lot of management for all those people that signed up. Once again, I'm Jessi Christensen, and I'm sure I have seen many of your faces before. I'm the lead of the eviction prevention programs at Good Samaritan, and I have been around for about 3 years. I've had the privilege of connecting with many of you, and I'm here to inform you about the new Ottawa County Eviction Prevention Program. However, before I begin, I want to give you an opportunity to participate. So let's see how this goes. So in the chat box, using 1 or 2 words, I'd like you to tell me what makes a good tenant. So this would be probably if you're a landlord or property management, what makes a good tenant in your opinion? We'll share a few of those as you put them in. Good communication, clean, pays rent timely. That's a good one. Paying on time. I think we're going to see a lot of pay on time. Quiet, respectful, being considerate, following policies and rules, payment on time, taking care of property, quiet, happy, communicates. We hear that a lot. Respects properties and landlords. All right, so next we're going to have a little fun with your thumbs up emoji. So you can find it by clicking your mouse on the reactions and selecting the thumb. So if you manage 10, or if you own or manage 10 or below units in the community, put your thumbs up. If you manage up to 20 units, add your thumb. How about 30 units? Up to 40 units? And add your thumb if you own or manage more than 50 units. Awesome. You can put your, whoops, sorry, I selected too many screens there. You can put your thumb down now. So thank you for doing that. I'm amazed at how many of you are here today and that you have chosen to rent units in Ottawa County. It can be challenging when you depend on reliable payments from renters and they encounter setbacks. So we hope that with the OSEP program, we can eliminate some of that stress when tenants do have setbacks. So OSEP stands for Ottawa County Eviction Prevention Program. It is a program that's funded by the county and it's in collaboration with the courts. The first goal of this program is to provide rental assistance to 40 Ottawa County residents each month that are behind on their rental payments. The next goal is that 85% of those Ottawa County residents will remain housed for 3 months after receiving rental assistance. We have specialists that work with each tenant to collect information and documents from them to help us determine how best to assist and if their unit will be affordable for them in the future. We would like to complete 1,400 screens annually. And as part of this program, we also are implementing a payback program. So tenants will be invited to pay back a small portion of the rent they received over a 6 to 12 month period. Our coaches will make sure that it works within their budget. As part of that payback program, our hope is that at least 85% of participants will make one or more payment back to the program. This is to provide sustainability for the eviction prevention program in the future and help more people that are in the same place as them. So who qualifies for OSEP? We can only assist Ottawa County residents. So if a person has a Holland address and lives in Allegan County, this grant will not be able to assist them. Household income needs to be less than 50% area median income. To give you an example of this, one person in a home can't make over $32,950 in order to be eligible. Two people, combined income for 18 or older, the maximum is $37,650. Three people, about $42,000. And so on, depending on how many family members are in their home. Those income caps are as of 11/18/22 and from MSHDA, and will change mid-year typically to the tenant's benefit. Third, they have to have an eviction notice or court summons. If they do not have this, they will be told they need to call back and pre-screen later. They also need a lease agreement. As part of our program, we need to make sure that tenants will remain housed for up to 3 months after assistance. So this is something we consider with month-to-month leases. Tenants also must be below $3,000 owed to the landlord. When researching successful eviction prevention programs nationally, most programs found that they capped assistance between $2,500 to $3,000, and they had the most successful outcomes for tenants and landlords and had strong sustainability. We are aware that as a community, that COVID rental assistance dollars were not capped for eviction prevention. There were families we served in our SARE program who received upwards of $10,000 for rental assistance. And that program was for pandemic relief and not a sustainable program, nor did it give room for tenants to plan for the long term. So I'm really glad we've had the opportunity to work more closely with those we are serving to help create longer, long-term housing stability plans. Next, they need to have a lease. Rent-to-own leases are not allowable. And then if they're only paying base rent, but they own their mobile home, they'll have to have proof that they're up to date on their mobile home payments. The landlord or property owner, property management company must be willing to accept payments on behalf of the tenant, and we'll provide an application for you to sign that says you're willing to accept those payments on behalf of the tenant. And then if a tenant is in court, they must also apply for the state of emergency relief with DHHS. So they can do this through their My Bridges account, and we have directions on how to do that and can also help them if they stop and see our staff when we're at court. So what does the process look like? So the notice is received. A tenant must receive a notice from the landlord of non-payment of rent or have a summons and a court date. Our goal is that the tenant pre-screens as soon as that first notice is given. Next is the pre-screen. It would be best at the first court date for the tenant to come speak to staff at court, where we are located weekly during the landlord-tenant proceedings on Monday. They can also call our office to do a pre-screen. And then we also have an online pre-screen that you could fill out with a tenant on our website. If the tenant is pre-screened eligible, they will be put on a list to be assigned to a staff to begin collecting documents for tenants. Tenants in court will be assigned first, as we know that time is limited. At that time, a specialist will also contact the landlord or property manager to fill out necessary forms for the tenant as well. At that time, our staff reaches out to you to collect that landlord application. It's an opportunity for you to share your thoughts or concerns that you might have regarding the tenant. If qualified, we will pay the landlord on the tenant's behalf. Payments are sent out about once a week. If a judgment has already been given, we will need verification that you are willing to wait for the payment and not file a writ for the tenant. The whole process from pre-screen to approval or denial is about 1 to 3 weeks, faster for those that are in court and assigned right away to staff. If a tenant is denied, you and the tenant will receive a determination letter. The tenant has the right to appeal through a written document, through mail, or by dropping off. If this is the case, staff will contact you regarding that appeal and let you know if we can reconsider that request. So what documents are needed from a landlord or property management company? We will need a landlord application signed that you are willing to accept payment on behalf of the tenant. We'll need a current lease with the tenant. We do pay attention to the end of that lease date, so staff may ask if you're willing to re-sign a lease with the tenant if the end date is close to our payment. We need a personally signed W-9 to send payment. And we also need an update on the eviction process for the tenants. When they pre-screen, they may only have received a notice of non-payment of rent. So if we call you and they're in court, please let us know. At time of pre-screen, if the tenant informs us they already have a judgment, we may contact you promptly before we put them on the list to be assigned to determine if we can assist them in a timely manner. So far, since the end of December, we have been able to assist the county with $250,000 in rent and helped 98 households. People like Tori, who received a cancer diagnosis during SARA. During that time, she was able to sign up to receive disability and move into a more affordable housing. After a recent health setback with medical bills, she got a couple months behind. And with OSEP, we were able to help her get caught up. She's working with a coach to find some part-time employment so she can manage to have more room in her budget and pay on time. Overall, so far, 600 households have been screened. Most of the tenants work with a coach for 3 months or so after assistance. They have been able to support tenants, help them with community resources, and budget management. One area that our coaches have been very successful is helping tenants find employment quickly with personal connections. There have been so many instances where tenants have gotten back to work quickly, earning enough to support themselves and their families moving forward. So we do have staff present in court on Mondays. Holland and Hudsonville from 9 to noon, and Grand Haven on Mondays from 1 to 3:30. We do work in coordination with the court, so we receive weekly dockets from the court and send them a list of those that have been pre-screened and are assigned, and those that have been approved or denied. Just FYI, those lists are sent to the court on Thursdays. So if a tenant calls our office and pre-screens, the courts may not know Monday morning if they have pre-screened because we sent those lists on Thursday. So that's just helpful information for you going into court on those Mondays. So we want to hear from you. Early in the program, we created a survey to get landlord or property management feedback, and many of you have given us some feedback already. We had probably about 20 surveys returned, so thank you for doing that. This program is very different from Sarah, and funding is from the county. And so we're thankful if you are willing to provide any input into the OSEP program. We seek to make this program work for our community, and any feedback is really helpful. So Esther is going to place this link into the chat box for you to copy and paste. It's a pretty quick survey. So after today or in the next couple days, if you could fill it out, that would be awesome. Thank you. So I just wanted to give you our addresses for Holland and our new office in Grand Haven. Our hours in Holland are 9 to 12. We're closed for lunch and then open 1 to 5 for people to stop in for applications or to drop off documents. Our Grand Haven office is open by appointment only, but if someone's in the Grand Haven area and needs to submit paperwork and transportation is a factor, we do have a Dropbox office or Dropbox located at that office on location that they can take their forms there and drop them off. Also, here's my email address. If you have any additional questions that come up later, I'm happy to answer any questions that you might have now, but I always go away from presentations and think of about 10 questions that, oh, I should have asked that. So please feel free to email me if you have any additional questions.
Jessi, are you finished?
Yes, I'm
I
finished.
put your contact information and the hours at the different offices in the chat box. And if you could pass on and make Dolores the host.
Yes,
Thank you.
yes. I know we practiced this, but for some reason I'm not seeing it. I clicked on the 3 dots and I don't see make host. Oh, maybe it's her 3 dots. That's what it is. Okay, got it. Thank you for your patience.
Okay, well, thank you, Jessi. Do I have to do anything to accept as host? I don't, right? Okay, thank you. Okay. I am Dolores Trese. I'm the managing attorney at Legal Aid of Western Michigan. We represent low-income tenants in court if they're being evicted, if they have a good defense. We have one attorney in our office who is doing almost all of our eviction cases now. Her name is Emily Evers. She's not available to do this today because she's actually participating in a statewide training today. I'm not going to present on all of the laws regarding landlord tenant, because that actually a good discussion on that would take at least probably, even a summary would take probably a good hour or more. And also, if you would like a good layman's guide to what the landlord tenant law is, and I don't really have a link for this, but there is a guide, and I will show you this here as best I can do. That doesn't work so great, but there is, this is a guide, which is, it's called A Practical Guide for Tenants and Landlords. And it's a booklet that is 60 some pages long. And it has a very detailed layman's description of landlord-tenant law. And it also covers tenants' rights, it covers landlord's duties. And this guide is provided by, it's actually created by the MSU College of Law Housing Clinic. And if anybody wants a copy of this guide, what you need to do is contact your legislator. All of it's produced by the Michigan legislature, so you can contact your state representative, your state senator, and ask them for a copy. You can also contact my office if you would like, and we will send you a copy. We try to get about 50 to 100 of these at a time, and we pass those out. It is, like I said, it's my concern is and it is very detailed, and there's so much to cover that I think a lot of people don't use it because they don't really, I think, to turn to it as a resource, or they don't know where in their particular issue is covered. But I can't recommend this enough.
Just real quick, everyone, I just want to let you know that the city of Holland on their housing site has a link to the handbook, both in English and Spanish. And I will be putting that into the link as well, so that you can have quick and easy access to it. It's a wonderful, I call it my Bible for my job here at the City Hall. So I'll put that on there for you, Dolores.
Great.
And
Thank you so much, Esther. I really appreciate that. So, but what I'm going to talk about is the issues that arise most frequently between tenants and landlords, that and what I call the pressure points or the pain points. Esther and I talk with some frequency, and we both say that we see the same issues over and over again. And Esther, working at City Hall, has tenants that come to her and they're very frustrated with their problems with their landlord. And sometimes Esther tries to contact that landlord and be a little bit of a go-between. I have a little bit of the same experience in that we get tenants when they're facing eviction, and our tenants are very frustrated. And then we have to go to court and try to negotiate with the landlord, or I talk to the landlord's attorney. And I see a real breakdown in two things. One, communication between the tenants and their landlords. And sometimes that's because of misunderstandings of what the law is. Sometimes the tenants don't have a very good understanding of what their rights are or how to enforce their rights. And sometimes I think landlords will sometimes have a better understanding of the law and what their duties are. And if they have a tenant that just doesn't understand things, the landlord might not be spending much time explaining things to the tenants. So I have this big, I think there's a big issue with communication. And the other part is, I think that there's a real lack of understanding on the part of tenants, as I mentioned before, what their rights are, how best to enforce their rights, or how to communicate with their landlord to ask that their landlord take care of whatever their issues are. So I'm going to be talking mainly, though, today about repairs. That's actually is one of the biggest issues. That it's probably the next one right behind non-payment of rent. Although we handle non-payment of rent cases, oftentimes there isn't much of a defense to non-payment of rent cases. And like I said, the pain point or the problem that we see over and over again, because there isn't a good resolution for it, is the repair issues. Another common issue is utilities, how they get paid, whose responsibility is it to pay it. And then I'm going to talk a little bit about some other issues we've been seeing a little bit more in the past few years. So in regards to repairs, a landlord has a duty to maintain the premises in reasonable repair. And as Judge Knoll was mentioning, there is a statute which uses that very language. It says it's the landlord's duty to maintain the habitability of the premises. There's also case law, which have cases that have been decided in the Court of Appeals that also outline when the landlord has a duty to make sure that those repairs are done And if they aren't done, that the courts have the ability to withhold or to say that the tenant does not have to pay all of the rents that they would normally have to pay. So the case law basically interprets contract law, which says that if the tenant is going to be paying rent and get something for the benefit, we call that the bargain for exchange. If the tenant's going to be paying rent and get the use of the premises in return, and the landlord is going to be receiving the rents, well, they got to give something in return. And what they have to give in return means that they have to have a reasonably repaired unit available for the tenant. And there's also in the city of Holland and a few other communities in Ottawa County that have housing codes, which are very specific as to what the level of repair that the landlord must meet. When we're if the landlord does not make those repairs, and we're actually in court, the court does have the option of, if there's a trial on the matter and there's testimony taken, the judge does have the option of being able to what we call abate the rent, meaning that they have the ability to reduce the amount of rent owed, and it's up to the judge. There's no formula for how much would be an abatement. That is really up to the judge to listen to the testimony and come up with what the judge believes would be a fair amount. That also affects when I'm negotiating with a landlord's attorney and trying to get a case resolved without going to a trial, and that there's no way to really say how much the value is of not having adequate heat for 2 weeks, or not having your water, or having carpeting that's been ripped and torn and not replaced. Those sort of matters, you can't really value that. So it's really ends up being something that everyone just has to kind of make their best guess. But I will say this, that I believe that everybody in the community has an interest in enforcing that duty on the landlord. We want rental housing in our community to be safe. We don't want it worn down. We don't want junky looking houses. We don't want basically slumlord types of places. There are communities in the state where if the landlords really don't keep up the value of the property, it affects the whole community. So it's something that we all have an interest in. We also want the families and the kids and the citizens. We want everybody to have safe and quality housing, because that makes for a better community for everybody to live in. But yet when tenants come to us, we frequently hear that they think that they have asked their landlord many times for repairs. And what I find is that communication level that the tenant actually has done, if the tenant brings that to me and I say, well, if I go to court on this, how can I prove this to the judge? Usually the tenant has very, very little or next to nothing to show me that I could actually take into court as proof. And so my response to that is, again, this is a communication issue, but not only do you have to communicate directly with the landlord, but if it's going to be successful, if you eventually go to court, I need documentation of that communication. So I am going to tell my clients, make sure you have put this in writing. And my advice will always be to anybody who's having difficulty with this is put it in writing. I would say, list each repair, describe it specifically. And then for each repair, you want to give a reasonable timeline for the landlord to be able to make that repair in. And then in your written communication, you want to advise that if it's not done within that reasonable timeline, then you will withhold your rent because the tenant does have the right to withhold the rent. The practical guide for tenants and landlords that I talked about earlier actually has on page 44 some very, very good sample letters, which you basically simply have to fill out the landlord's address and name and sign it. And of course, you'd have to list your own specific repairs, but they have a progression of letters that can be sent to the landlord. The first one is just the list of requested repairs. The next one is the tenants that if that doesn't get the job done, there's a sample letter that the tenant can send saying, if these are not done, because they haven't been done, I intend to repair and deduct. That's one option that the tenant has, is they can also do the repairs themselves. Or this is my intent to withhold the rent because it wasn't done. But there's a progression of letters, and that way, if the repair does not get done and the tenant is withholding their rent, or the tenant has made their own repairs and deducted that from the rent, and if then the landlord tries to proceed to court, we then have documentation to take to the court to show to the judge that the landlord did not meet his statutory obligation to maintain the premises. And we also have the ability to prove to the judge that the landlord had knowledge of the need for repairs, but the landlord also failed to act to make those repairs. And I have found that in situations, once you do those written communications, landlords are very responsive. They know what their duty is, it's clear to them, and they also know that if it's in writing, they've got to follow through. So again, it's the writing of the communication that's very important. But in the past few years, what I've noticed is a change. Rather than people writing each other letters, people communicate via text. Larger complexes often have a portal, which is great for this purpose because tenants can then just put their request in the portal. It's documented, everybody's seen it, and that works very well. But we also have a lot of landlords who are mom and pop, what we call mom and pop landlords, or private landlords. They are individuals, they may own just one unit, they may own 5, 10, 15 units, but they're the ones which they probably or may not have established quite a good of a method for communication with their tenants. So what I often see, however, nowadays is text messages. And when tenants come to me and say, oh yeah, my landlord knows about this, they'll show me a chain of text messages where maybe the repair was mentioned in with several other items that they were discussing, and it isn't a clear enough communication to prove that they actually requested the repair from the landlord. And it also is just not, when you just hide that communication in the chain of other communications, it just isn't enough of a notification to the landlord to say, hey, I really need you and expect you to pay attention to this. And as I mentioned also, that the tenant does, if they want to choose this option, which is to make the repair themselves and then deduct the cost of the repair from their rent, they are going to need to have documentation of what they spent on those repairs. So whatever their supplies were, if they have receipts, that's wonderful. In terms of the labor, the statute actually does say that the tenant can charge a reasonable cost for the labor. So whatever would be the reasonable amount for that labor, but they would have to document their hours so that if I go in front of the judge, or if I'm negotiating with the landlord or the landlord's attorney, I have something to back up why we're asking for the amount that we're asking for. And this includes And not only does the tenant have a right to ask for a reasonable cost for their labor, but in situations where the landlord is making a repair and they can charge it to the tenant because the repair is for a damage caused by the tenant, the landlord also has the right to charge a reasonable cost, not only for the cost of the supplies, but also for their labor as well. So I have tenants who get a little surprised when a landlord makes a damage repair and the landlord is charging $15 an hour or $20 an hour or whatever for that repair, but it is reasonable. So in terms of the common issues of where I see repairs not being made that easily could be, and like I said, I don't see this usually in large apartment complexes. You do sometimes. Sometimes you have it in large complexes. What my tenants will usually be frustrated with is the lack of time in that you request a repair and it might take a week or 2 weeks for the maintenance person to be there, or it might be that they don't get notice of when the maintenance person is going to show up. So again, that is a communication issue, which, if anything, I could give advice to landlords is to try to maintain that communication as best as possible. It reduces a lot of frustration on the part of the tenant. When there's that lack of communication, both the tenant and I believe the landlords get frustrated with each other. And if there were better communication, sometimes I think that would eliminate a lot of eviction cases, and because they haven't gotten to this frustration point where they're both just done with each other. However, but I do want to say we see a lot of problems with plumbing, sinks that are backed up, sinks that leak, toilets that leak, toilets don't flush properly, or leaks in bathrooms that are causing mold in the bathroom and the leaks don't get repaired, or the leaks have been going on for so long or they're so extensive that they damage the ceiling of the lower unit. We've seen collapsed ceilings in the lower units, rotted floorboards from leaky plumbing. We also see problems with furnaces that need that in the fall aren't coming on, a lack of delay in getting furnace repairs made. And then there's the general, this window won't close all the way, the door won't close all the way, I have a cracked window, those sorts of repairs. Another one that I've seen several times in my practice is basements that flood and not being cleaned up quick enough, which of course cause a lot of mold growth. And again, that's sometimes is a communication issue. The tenant will report the problem to the landlord, but there's a delay in the landlord addressing the flood issue. And then what we end up with oftentimes is the tenant may have had stuff stored in their basement, and so their property is being damaged. And they're so frustrated that they start withholding their rent, and then the landlord takes them to court. And what we're fighting over is whether or not the landlord or the tenant had a right to even store their stuff in the basement. And again, that is is something that could be addressed with leases if they were more specific. I see again when somebody is renting a house and perhaps there's an upper unit and the lower unit and there's a basement, and the lease isn't clear as to whether or not the basement is part of the lease, or does the tenant have the right to use it as storage? And I just see that creating a lot of friction, and that landlords will get upset because they don't think the tenant had the right. They don't believe that they ever gave the tenant the right to use it, and the tenant just assumed that they did. And that is something that could have been cleared up with a more well-drafted lease. Another friction point we see is with utilities. And again, this is definitely an issue, not in larger complexes, but with private landlords. A well-drafted lease says who is going to pay for the utilities. And often they say that the tenant must put the utilities into their name. But a poorly drafted lease will, in situations where there is no lease, the landlord will simply tell the tenant, well, you have to pay the utilities. But there's no description of how the tenant is going to know how much the utilities are. And situations where you have 2 units, both in upper or more units in one building, landlords not uncommonly will just simply tell each tenant how much they owe. The landlord keeps the utilities in their name and gets the bill from the utility company. And then without producing a bill, sometimes there's no agreement as to how it is divided up. Is it 25% each? Is the upstairs tenant, which is bigger, should they have to pay more for the gas? None of that is in writing. This is something that could easily be covered in a lease. And this friction also comes when you have a landlord who only has 1 meter for several units. And so it's always a guess as to how much each is supposed to pay. And it's something which I think I have seen landlords take advantage of that. And I've seen tenants feel like they're really taken advantage of, and that one tenant ends up paying a higher portion of the utility bill. We recently had a case just last fall where we had a tenant who, after paying the utilities for months, realized there was only 1 meter and he was paying his upstairs tenant's electric bill. And he tried to raise that issue with the landlord and didn't get a response. So he stopped paying the electric bill altogether because it just wasn't fair. And then the landlord in response just cut off his utilities, and which is an illegal lockout, and you're not able to do that legally in Michigan. And so we had to go to court and get an injunction against that landlord to force him to turn the utilities back on. And then we had to litigate the issue of whose responsibility the unpaid utilities were. And so again, that really is something with better communication up front, and with a landlord doing a better job of addressing that, with putting it in the lease, making it clear how the tenant is supposed to know how much they're supposed to pay, providing a copy of the actual bill to the tenant. Those all really help a lot in keeping things running smoothly. So,
Dolores,
yes.
I'm sorry, I didn't mean to interrupt. Go ahead and finish that thought.
Okay, nope, that was, am I kind of running?
No, you're doing just fine. I wanted to pose a question because in the last couple of weeks, I have had a lot of calls regarding allowable security deposit monies that can be withheld or not returned. So wondering if you can cover that. It's 12:57, so we're almost there with time.
Okay, sure. So, and you know what, I feel very comfortable addressing that because I pretty much had covered what I needed to cover. But so a security deposit, the amount of a security deposit can only be 1.5 times the monthly rental rate. And the landlord has to put that security deposit into escrow. But the question always becomes is when the tenant leaves, how does the tenant get that security deposit back and how much are they entitled to? So the first thing to know is that the tenant, when they leave, only has 4 days to notify the landlord in writing of their new forwarding address. So, and they have to notify the landlord at whatever is their usual communication or whatever is the method outlined in the lease. But without that tenant providing that forwarding address within 4 days, the landlord no longer has the duty to return that security deposit. It can actually keep the whole entire security deposit. So that's why that's the first part. It's most important. Then the landlord has 30 days from there to provide a list of itemized damages. And the damages has to be for actual damage, not normal wear and tear of, I've been living here for 3 years and this is a little bit worn and that's a little bit worn. It has to be damage caused by the tenant. And again, it has to be in writing, sent to that forwarding address. Once the tenant gets that, again, the next step that the tenant must follow is if they object to any of the amounts that are being claimed by the landlord, is they must respond within 7 days and outline what their objection is and do that in writing and send it back to the landlord. And as to how much those repairs or the damages, what the value of them are, there is no set formula. There's no actual way to determine that. The landlord usually just calculates how much they spent on making the repair and deducts it from the security deposit. So sometimes we do get into disputes as to whether or not the amount that the landlord is claiming is reasonable. But again, it's all it's all arguable. It's no clear cut and it's all negotiable. Then if the landlord fails, once they get that written letter of the objections, has two options. They can either pay the amount that the tenant claims, that the tenant believes that they are entitled to of their security deposit in return, or they can, within 45 days after that, take the tenant to court and establish the amount, to have the court determine the amount that's owed.
Dolores, quick question from the audience. For damages, must letters be sent via snail mail or are emails or texts allowed?
So the best thing to do is to look at the lease. If there's a lease, the lease should say specifically how to contact the tenant or how to contact the landlord. Whether nowadays landlords are using portals and all communication must be through the portals. The lease usually has an address for the landlord, and unless it says otherwise, you do need to mail it to the landlord at the address in the lease. Unless the lease says something else. The lease might say text messaging is okay. Or it might say, another method, but otherwise, yes, mail. And I do recommend when in these communications with the landlord that the tenant take it to the post office and get a receipt of mailing. You don't need to send it certified mail, but for $1, the post office will give you a receipt showing that you did mail it and the day in which you mailed it.
And another question that I regularly get is, hey, my rent went up by XYZ. Is there a minimum? I'm asking this question. I know the answer, but I'm asking this question so that we all hear it. Is there a minimum amount that the rent should be increased? Are there any guidelines in the state of Michigan for that?
No, there aren't. It's a contract. And when your lease is up, and if your lease is being renewed, and if it's not subsidized housing, the landlord can raise it to whatever amount they think they can get. So that amount for the term of the lease, the landlord is stuck to whatever is in the lease. But once the lease is up at the renewal time, any amount is allowed.
That very rarely happens, but I have seen where tenants have had, maybe they've been paying $750 for 5 years. And in this market, our landlords are recognizing, hey, I can get a little more, and they increase the rent and it becomes a concern. So I just wanted to pose that question out there.
Okay, certainly. Yeah, no problem.
Are there any other questions from the audience? Feel free to raise your hand or put the question in the chat. Dolores, if you have anything else you'd like to add that you didn't cover, feel free.
Nope, I'm good. Thank you.
Kristen from the Michigan Department of Health and Human Services. See that your hand is up.
I had a question. It probably doesn't happen that often, but sometimes renters will have a lease, and at the end of the lease, like if you have two people living together, one of them will leave, and then the other one will want to stay, so they want a new roommate, or something like that. And so how does the security deposit work when the people have kind of changed? Or is it like a complete new lease and one person staying, so they stay under their original security deposit, and then the new person? It seems like it gets a little confusing.
I would say absolutely. And part of what's confusing is if you're in a lease, and at the end of the lease, nobody has officially done a second lease, you actually become a month-to-month tenant. And in some situations, such as a mobile home park, your lease actually renews for a full another year. And so, but at the terms of the previous lease, the terms of the lease don't change, but there's actually no written lease in place anymore. So it can be really confusing when, like you say, one person wants to continue with that lease that's in effect, that was in effect, and the other person doesn't. So what ideally should happen is the person who's leaving should provide notice to the landlord, saying with the 30-day notice, saying, I do not intend to renew this lease, I'm leaving. And that way the landlord has notification that as to that tenant, that lease is not renewing. So, and that limits the obligation of that tenant to continue paying rent, even though their roommate may still be living there. And we've had problems with mobile home parks 3 years later, because the 3-4 years later, wanting to sue somebody who moved out 3 or 4 years ago, because the mobile home park is saying, the lease renews every year, you're still liable. We go into court and we argue that that's not right, but I have seen mobile home parks try to do that.
Thank you.
I don't see any more raised hands, and I don't see any more questions here in the chat. I would like to thank everyone for being here today and being part of the presentation. We like to bring meaningful information to the community, and we recognize that we have individuals, we have residents, we have both tenants and landlords that we serve here at the City of Holland, and we are always looking for ways to better serve you. If you have any recommendations or suggestions, please reach out to me. I'm going to put my email here in the chat box, and I hope that you will reach out. And if you have questions, I'd be happy to address them, or reach out to either Judge Knoll, Jessi Christensen, or Dolores Trese at Legal Aid of Western Michigan. Thank you so much for being here today. And let me finish putting my email in the chat box. Thank you all.
Thank you all as well. Have a wonderful day.